law under Israel occupation.
Yeah, but I'm open to suggestions. I'm not a big fan on the title. Two apologies. First, contrary to what may be appearances, I'm barely alive at the moment. I'm a bit, and so I prefer to read the paper, which I don't usually prefer, but I don't feel at my best. And secondly, is that much more philosophically and ontologically, I'm not an international lawyer. I came onto this subject or topic because I was asked to review 4 books on the occupation. I'm quite active in several human rights organizations that at the moment exist, but they may well be outlawed very soon. What came to mind, I teach jurisprudence here, and what came to mind was Professor Lon Fuller's writings. And it just occurred to me while I was reading kind of thousands of pages on the details of the occupation that what we have here is a structure that befits Lon Fuller's analysis. Now, for those of you who are familiar with Lon Fuller, a caveat is necessary because Lon Fuller writes after Second World War and with the context of Nazi Germany regime, and a bit about apartheid is also mentioned. I'm not necessarily drawing any comparisons here. Obviously, systems are very, very different, but I'm employing his theory instrumentally. So in a chapter unequivocally entitled The Morality Which Makes the Legal System Possible, Professor Lon Fuller lists 8 conditions of natural procedural law, which separate a legal system from an arbitrary system of power. The conditions include generality, prospective legislation, clarity, lack of contradiction, absence of requiring that which is impossible, consistency, and a correlation between requirements of law and its actual application. According to Fuller, these conditions determine the ability of a system of law to legitimize its actions, so nicely kind of connected to Oliel's paper, or to the final kind of comments. A system that strays from this ideal loses its moral ability to compel compliance. So what I would like to do is employ Fuller's analysis for a review of the legitimacy of Israel's legal system that governs the Palestinian territories conquered in 1967. One indeed may argue that any lasting occupation with no time limit is wrong and perhaps illegal in itself. Indeed, Eyal did so. But for many, the existence of a functioning legal system in the occupied territories constitute a certain answer to the position which categorically objects to the moral and legal legitimacy of the long-lasting Israeli occupation in the territories. Therefore, we must examine the justification underlying this argument. The significant advantage in the Fuller approach derives from the elegant bypassing of moral disputes that exist between different segments of the population which are difficult to resolve, and focusing on those parameters which even the disagreeing parties are expected to agree upon. A procedural view has great power due to its ability to rally a wider consensus around the perception of justice and fairness in the system. Fuller widens this understanding and reviews not only justice within a system, but also the criteria for justice and fairness of the system. In doing so, he is well aware of the difficulties of creating substantial standards for reviewing a legal system, yet he offers the above stated 8 procedural principles. With respect to Israel's control of the occupied Palestinian territories, OPT for short, we find that 7 of the 8 principles listed by Fuller are manifestly violated in the daily and legal existence of the Israeli occupation. Only prospective requirement or the requirement to refrain from retroactive legislation is not clearly demonstrated, but this is work in progress, so I may come across it as it progresses. The first is generality. This requirement may be framed in more basic terms, according to Fuller, the requirement for the existence of legislation. This requirement may seem very basic to anyone interested in the rule of law. However, the mere existence of legally binding orders is not enough to fulfill this requirement. The requirement is that legal norms will be sufficiently general, not directed at specific individuals, but rather at sufficiently wide segments of the population. It is fulfilled when the legislation is directed at the bureaucracy and governs its actions. However, when this liberal model of the bureaucracy retreats, it is replaced with the whimsical bureaucratic discretion, which Carl Schmitt termed constant decisionism. In the case of the Israeli occupation of the territories, the juridic sphere normally occupied by acts of legislation, a result of a deliberative democratic process, was replaced by administrative orders, ordinances, and ad hoc decisions which respond to the changing conditions and needs. These sometimes overlap and sometimes replace one another in a disorganized fashion and have never been collected into a single organized codex. Estimates are about 2,500 military orders, which in a kind of fuller version of the paper, I discuss their normative hierarchy, but in some cases they're considered to be primary legislation. A relevant example of this phenomena is the imposing of curfews in the territories. According to Shlomo Gazit, the first commander of the civil administration in the territories, during the first 2 decades, a complex procedure was applied in regard to the imposing of a curfew. The procedure required that the lower-ranking officials submit a request to be examined by higher echelons of the army all the way up to the chief of staff. The rules required that the purpose of the curfew be stated, along with the forces placed in charge and the length of time of the curfew. A parallel procedure was also required on the civil side of the Department of Defense, including the approval of the Minister of Defense. Pursuant to the outbreak of the First Intifada in 1987, decisions regarding curfews were relegated bit by bit to the local level, subject to a simple and routine procedure by the commander in the field. Gilad Dayan termed this phenomena the rule of executive tyranny. The immediate result of this change was a substantial increase in the days of curfews in specific villages. For example, in the month of January through March 1991, the village of Anwata in the area of Tulkarem was under a curfew for 74 days out of 90. And during this time, the curfew was lifted only sporadically. Commanders could close the roads, impose a curfew on entire villages in reaction to a security event or in preparation for Jewish holidays when many tourists would be expected to visit the country. Another example is the result of the serpentine route of the security barrier. The barrier encloses, amongst many problematic things that it does, it encloses an area of 530,000 dunam in which 8,000 Palestinians reside in 21 villages on the wrong side of the fence. The villages are imprisoned between the green line and the separation fence in close proximity to the settlements. The physical barrier therefore required legal tools in the form of permits regime, which constitute part of the aforementioned principle of administrative tyranny. Palestinians in the area require permits to continue residing in their own houses, in their own villages, and they must periodically renew these permits. They also need a special permit to be allowed to work their land, which is sometimes on the other side of the fence, to go to school, to seek medical treatment, or to visit relatives. This permit includes details regarding the journey's destination, the gate through which the exit is permitted, and times when the permit is valid. As a result of all this, all business, family, and friend relations of the residents of these villages depend on decisions made by military commanders. A final example is the decision handed down recently by the High Court of Justice, which canceled the travel prohibition of Palestinians on Route 443 from Tel Aviv to Jerusalem that goes through the occupied territories. This prohibition came into effect in the year 2002 and was employed without any written empowerment, the prohibition on the travel of Palestinians, but only on the basis of a general authority of the military commander to order a road to be closed on the basis of his general authority and security issues. In fact, only after the petition was submitted in August 2007, 5 years later, did the commander of the military forces in the territories issue orders forbidding the travel of non-Israeli vehicles on the road. Despite the fact that with the publication of these instructions, the argument regarding the lack of legal authority became invalid, the court reviewed the practice of imposing a prohibition on travel without written authorization, which repeats itself over and over. The court states that the obligation to publish a specific order is in both the interest of the harmed parties and of the respondent. In the absence of a signed order, a lack of clarity may arise, even among governmental agencies regarding the understanding of the actual situation. This has been the case here as well. I return to clarity in a second. The second criterion is publication. This basic requirement demands that rules of law be published so as to allow the public to scrutinize them, criticize them, or demand their enforcement when the need arises. Legislation in the territories is subject to limits placed upon it by the legislator, who is the military commander. In this regard, the military commander set in law the fact that he is not required to publish his actions. I quote, "A manifest order or message of the military commander will be published in any way he himself, sees fit." The system of permits exercised today in the territories serves as an example to a blatant violation of a publication requirement. Criteria for identification, separation, and restriction for reasons of security are not published, thus denying the public a rational discussion by which one may argue or disagree with the logic they are based on. Applications for the publication of criteria were denied by the Attorney General's Office for the Territory of Judea and Samaria, the West Bank, for reasons of security. The military's response is often that the exit permit is specific and not general, so this kind of connects nicely with the generality requirement, and that the considerations that it is based upon may change from time to time, and that I return to that as well. The third criterion is clarity. Fuller views this requirement as forming a basic and essential component for legality. Vague and unclear legislation cannot be the basis for compliance. Interestingly, for me at least, he quotes Professor Friedrich Hayek, stating that one could write a history of the decline of the rule of law in terms of progressive introduction of vague formulas into legislation and jurisdiction, and of the increasing arbitrariness and uncertainty of, and the consequent disrespect for, the law and the judicature. I think this fits nicely with my general theme. Legal and political ambiguity and the partial suspension of rights are a basic part of imperialistic rule, which is based on political system built as a patchwork of legislation with local arrangements and many exceptions to the rules, designed to preserve the interests of imperialistic powers. In place of clear legal categories that are based on known criteria, imperialist powers prefer a vague system of relations, loyalties, and alliances as their work model. Turning to the occupation, one may examine the requirement of clarity in terms of macro and micro. In the first context, while the Israeli legal system has never recognized the West Bank and Gaza as occupied territories, and Netanyahu's speech yesterday was perfect for me, it justifies the acts of Israel and the rights of Palestinians on the basis of laws of occupation. In the same way, the Israeli Supreme Court, which has not declared that the Geneva Convention applies to the territories, has applied its principles and denied the majority of Palestinian petitions on the basis of exclusive contexts dealt with specifically by the Geneva Convention, deportation and destruction of houses. Adi Ophir and Ariela Azulai view the political framework set up by Israeli policy as based on the intention of causing the territories of the West Bank and Gaza Strip as a zone of indistinction between different types of violence, which under the rule of a sovereign government are separated. These are mainly the distinctions between tangible outbreak of violence, withheld violence, and insinuated violence. I refer you to their writing. They have a full 100-page chapter on this. They state that typically the transfer from typically in a proper democratic regime, the transfer from one type of violence to another is well regulated by clear rules which enable a person to plan his actions accordingly. When a power loses legitimacy and stability, it tends to apply it in an irregular and ad hoc fashion. The increased use of camouflage soldiers moving rapidly from blending into the community to committing serious acts of violence is a clear example of this. However, beyond the level of legitimacy, which the system as a whole may reap by its built-in ambiguity, vagueness is also an important and problematic component in specific cases. Thus, for example, the legal settlements cause a change in the legal outposts, what is usually termed in Israeli discourse, cause a change in the perception of existing legal settlements or whatever, other settlements. The legal settlements have become a clandestine governmental project, and the distinction between legal and illegal has certain advantages for Israeli government policy. Since the settlements are illegal, the government can remove them. They do not have clear sections relating to their existence in budget books, they do not appear on official maps, and there are no clear rules relating to the way in which government is to deal with the residents, land, structures, and facilities. It's kind of a legal limbo. On the other hand, since the illegal settlements and locations are known, a way is found to place guards on site for them, to hook them up to electric grid, to pave access roads, to provide them with a local ambulance, military escort for children traveling to their schools. Under such conditions, it is impossible to stabilize the distinction between the so-called legal and illegal aspect of this existence. Another rather severe example has taken place recently with the enactment of the order, military order, for the prevention of infiltration. This order was signed into effect on October 13, 2009 by the commander of the military forces, but in the manner already alluded to above, was published only on that very day. According to this order, an infiltrator is a person in the area without a lawful permit. An infiltrator may face deportation as well as criminal proceedings carrying a sentence of up to 7 years. The vague language of this order enables it to be applied to Israeli citizens, even settlers don't have such permits, to Israeli citizens and Palestinians, Jews and non-Jews, residents of the Gaza Strip staying in the West Bank, residents of East Jerusalem, and citizens of country with which Israel has diplomatic and friendly relations. As this order does not define the term lawful permit, the military commander could, if he desired, empty the West Bank of all its residents, subject to judicial review, of course. On the other hand, an announcement made by the army spokesman clarified that this order will not be employed against Israeli citizens, and that a priority would be made to use it against residents of Gaza residing in the West Bank. This spokesman announcement serves to illustrate the danger of the lack of clarity. Vagueness enables arbitrary action, the lack of predetermined limitations, and the placing of a single individual, a ruler or a military commander, above the law by virtue of his being the maker of the law for all intent and purposes. The fourth one is not demanding the impossible. Prima facie, Fuller explains, legislation requiring the impossible constitutes an absurd that even an evil dictator should not have any interest in adopting. However, he concludes that sadly reality is more complicated. He refers to the relatively marginal phenomenon of absolute responsibility in criminal law, so this kind of fits nicely, which was never very popular precisely because many were hesitant about assigning criminal responsibility to a person for an act he could not avoid. And yet the solution to this situation in many cases is found to be worse than the original problem, selective enforcement. Despite the fact that the norm applies to the general population, we are assured that its enforcement will be directed only at the true criminals. The honest citizens who are exempt from criminal responsibility by the authorities are grateful for this kindness bestowed on them. The practice termed by Fuller as enforcement by way of extortion was commonly practiced during the course of World War II. Tools of extortion are employed in a disturbingly frequent manner in the context of the Israeli occupation of the territories, mostly in order to recruit Palestinians with security forces. This is a situation in relation to exit permits for the purpose of medical care. Dr. Ephraim Sneh, by the way, medical doctor, who headed the civil administration, stated that Israeli policy is designed to pressure the Palestinians to cooperate in many fields. Our motto was, if you behave well, you'll receive. If not, then no. This policy was not explicit, but it was known to all parties involved and was mentioned in internal discussions, end quote. What? Good, thanks. Thousands of Palestinians were recruited in this way as accomplices to the general security services, providing information, assisting the incrimination of others, leading to rapid erosion of relations of trust and friendship within the Palestinian society. In other cases, the demand was not for cooperation, but rather for voluntary expulsion. For example, people seeking medical treatment were permitted to exit on condition that they sign an agreement stating that they will not return to the West Bank or Gaza for a stated number of years. The same is true of those seeking higher education, as exemplified by agreements signed by students, this is published recently, pledging not to return to the West Bank or to the territory of Israel until the completion of their studies, and in any case, for a period of time, no less a designated period of time, the later of the two. At times, the offer is not an invitation to improve the condition of individuals' medical care or studies, but instead a threat that his or her condition may be worsened. In this way, it was recently revealed that the Israeli General Security Service turned to medical students of Al-Quds and conditioned their continued study and their internship on providing continuous reports on other students. The fifth one is consistency. The rationale behind requiring the avoidance of frequent changes in legislation is similar to that of avoiding retroactive legislation. For those non-lawyers, there are two of them still in Israel, for those unable or unwilling to follow the legal situation, rapid changes in legislation denies them the ability to plan their actions and to act on the basis of reasonable expectation as to the legal situation. However, while retroactive legislation if it exists, is a minor phenomenon in the territories, the situation of rapidly changing rules in a whimsical way is central to that legal system. A striking phenomenon in this context relates to the infringement of freedom of movement in the West Bank. Part of these changes relate to the irregularity of times of gate openings in the separation barrier, already mentioned, but also to decisions regarding curfews and closures. After the second Intifada in September 2000, so what we see here is a significant deterioration in all these respects. The army began making use of a new practice which made it even more difficult to plan actions and perform daily activities. Surprise roadblocks, also known as mobile roadblocks or flying roadblocks. Jumping. According to the records of the United Nations Office for Coordination of Humanitarian Affairs, an average of 100 surprise roadblocks were set up per week. The inability to base a regularity of time and space harmed the ontological security and the connection between the individual and his or her environment. The situation is reflected by the fact that newspapers and local radio stations in the territories report the roadblock situation along with the weather forecast so as to enable people to prepare for traveling during the course of the day. Even worse are the frequent changes made in the rules for opening fire. These rules change in time and location without the existence of a binding, organized, and rational framework for these rules, and they are not obviously clearly published. Existing documentations point to a deterioration that has taken place in this respect. In the year 1990, constrictive rules of opening fire were published, defining the conditions in a very limited way, citing situations of life-threatening danger, and only as a last resort. At a certain stage, as part of a policy to limit the scrutiny of military procedures, the rules for opening fire over the years were no longer published and released to the general public. However, the characteristics may be thought on the basis of testimony of soldiers which were collected by the organization Breaking the Silence, Shofrim Shtika. In the Fuller paper, I have kind of a detailed description of the new the orders for opening fire. The sixth one is absence of contradictions. Fuller recognizes the difficulty in designing a complex legal system which is perfectly devoid of contradictions. Such contradictions are typically examined when they are discovered and settled by the relevant institutions, legislators, or courts. Here as well, a distinction may be made between the macro and micro contexts of avoiding contradictions. On the macro level, an obvious example is the contradiction between the massive investment in the settlements and the consistent claim that the occupation is temporary. This is Ayad's part of Ayad's argument. For a long time, the title of temporary character of the legal arrangements granted immunity to a policy that, on the face of it, should have garnered more severe criticism in Israel and abroad. However, and in a way consistent with the Fuller analysis, and this is kind of looking towards my conclusion, at a certain stage, the legalistic legitimacy has lost its strength. The contradiction between the declaration of temporary presence and the long-lasting influence on the lives of residents have led to a lack of trust in the Israeli position regarding its desire to reach an arrangement that would include a withdrawal from territories. From a localized standpoint, the policy regarding passage serves as an example not only for rules that remain unpublished, but also to conflicting structures that don't allow the planning of daily life. For this reason, for example, Palestinians are already accustomed to refraining from announcement of the actual time and place of a weddings on the invitation. Instead, the common practice is to write 2 or 3 possible times in which the event may take place and to send a quick message when curfew is lifted, roadblocks are cleared, and they can invite the guests. Seventh one is a correlation between the law and the actions of... -1. Okay. Okay, the final criterion for interoperability is the most complex one between the requirements of law and its enforcement. According to Fuller, the requirements of law may remain unfulfilled as a result of misinterpretation, unavailability, corruption, misdirection, indifference, stupidity, and personal interest. The gap between provisions of law and its enforcement do not receive enough attention, especially when they are institutional. I have here a list of cases where the very few cases where the Supreme Court accepted petitions by Palestinians and they were not enforced. Security barrier is an obvious example. There were several of these cases. Security barrier still remains where it stands. Violence applied against Palestinians, targeted killings, Of course, even on the occupied territories, there is an offense of murder, but no soldier has seen the inside of a courtroom in that respect. And needless to say, demands made by humanitarian organizations that the army investigate cases of civilian are sweepingly denied. So this again fits with Ariel's. So what is the result of all this? What does this failure mean? Fuller states that a significant failure of internal morality tends to be cumulative. Frequent changes of legislation may lead to the avoidance of legislation or the publication of rules. Legislation demanding the impossible is expected to lead to selective enforcement and to the creation of a gap between the formal rule and the situation in reality. The repercussion of this state of affairs with respect to legitimacy that a legal system wishes to attain is clear. Those subject to the law cannot and should not be expected to internalize the law and the subordination to it. Thank you very much.